Okay, good morning, everybody. Welcome. On Monday, we were talking about MiFID II, and this is the last slide that we saw. It's a sort of a recap of what's truly new in the context of MiFID II vis-a-vis MiFID I. So just to go back on this last slide, we saw that it is a complex, not just a directive, it's a complex normative package. There's a strong role now being played by ESMA that sets out interpretative practices, guidelines, opinions, and this reduces the role of national competent authorities and national legislators. We have a new map of trading venues. We will talk about that today. And the MiFID II has specific attention to recent technological developments, and it regulates phenomena which are purely technological, such as high-frequency trading and algorithmic trading. This is a peculiar feature of MiFID II. It is probably, in this respect, the only provision of EU financial legislation that truly has this technological echo coming in. At the time when MiFID was prepared and discussed, the fintech phenomenon was virtually non-existent, and so MiFID does not really take into account the most recent market's evolutions on fintech, and naturally the pandemic has accelerated the tendency towards fintech in all across the financial market. But even though MiFID is sort of lagging behind the most recent evolutions, such as blockchain, distributed ledger technologies, crypto assets, it is nonetheless interesting because it includes these rules on high frequency and algorithmic trading that we will consider in due course. Now, just as in the banking context under CRD4, the central definition around which everything is built and constructed is the definition of credit institutions. In the context of MiFID II, the central definition is the definition of investment firm that is based on two other definitions, and in particular the definition of investment services, and we will see, investment services and financial instruments. This is what we'll be talking about today. What are investment services and what are financial instruments, even though I think that we won't really be able to cover both topics, and we may need to discuss the definition of financial instruments on Monday. So let's start from the core definition of investment firm. We know, I told you on Monday that the directive applies to investment firms. It also applies to credit institutions when they provide investment services or activities. But the vocabulary of the directive is built on the notion of investment firm, and this is defined as a legal person whose regular occupation or business is the provision of one or more investment services to third parties and or the performance of one or more investment activities on a professional basis. So it's a definition which is based on another definition, and the latter is investment service and activity. But let's look at the notion of investment firm before we consider the definition of investment services and activities. If you look at this definition, you see that it is based on some sort of qualifying elements, and these elements are, first of all, reference to a legal person. Second, a legal person that provides on a regular basis or as a regular occupation or business. So the concept of regularity in providing the service. A third element is the provision of services to third parties. And the fourth element is the professional basis. Now, we could spend a lot of time discussing all of these elements, but I want, first of all, to point out that the definition of investment firm is not simply that of a person who provides investment services. If we were to read in Article 4.1 something like, I'm writing on the chat now, an investment firm is a legal person that provides investment services or activities, something like that. If this were the definition, the situation would be quite different, because we would say that the simple provision of an investment service or activity would mean that the directive would apply. But instead, the definition is more precise. The one that we find in Article 4 is more precise because it requires an element of regularity. It requires that services are provided to third parties, and it implies an element of professionality. It's a very important thing to note, because it means that the directive has been sort of framed in a way that looks at avoiding, or rather finding, an equilibrium between costs and benefits of the regulation. It's a typical approach of what we already saw at the beginning of the course when I spoke about the concept of better regulation. Regulation is sort of suited in order to combine costs and benefits. If the directive had followed the wider approach, the one that I wrote on the chat, the directive would have a very and truly comprehensive scope of application. And it might ultimately capture entities and activities that really do not justify the burden and the costs that are a consequence of MiFID regulation. MiFID regulation is very expensive in terms of costs for the system. It is expensive because getting a license is a complicated topic in member states, and it requires significant investments by market operators getting the license. It has extensive costs in terms of compliance with the rules by market operators. And these are private costs that are obviously then sort of shifted to the consumer, because these costs are incorporated in the cost of the services that are provided to the market. So ultimately, transactions on the market become more expensive because of this mechanism. It also has public costs, because MiFID requires supervision, and supervisors are expensive for the system. And supervisors are basically paid out of taxpayers' monies, even if there is a system of private contribution, whereby you see that in most member states, this is not mandatory, but this is a national choice. In most member states, the supervisors levy private fees on market participants to cover part of their expenses. But in any case, the public money is used in order to supervise. So you have to find an equilibrium between regulation, costs, and benefits at the same time. The suggestion to eventually consider simply writing that an investment firm is a legal person that would expand the scope of the directive. And then you will have to wonder whether this is reasonable in terms of costs and benefits. The answer provided to this question is no, this is not reasonable. And so the directive has been drafted in order to capture those activities that are truly relevant for the market in terms of controls and supervision. So it needs to be a business which is carried out on a regular basis. So a one-shot transaction that might be considered as an investment service, we will now see what investment services are, is not sufficient in order to trigger the application of the directive. The services need to be provided to third parties, and this means that investments that are provided only to group companies, companies belonging to the same group of the investment firm are basically excluded, because a group of companies is considered as a single economic entity, so there is no provision of services on the open market. And also on a professional basis. And the professional basis is basically understood as an activity which is carried out through an appropriate level of organization. So the concept of professionality, which may be confused with the concept of regular occupation or business. If you look at this definition, you might feel that there is a little bit of a repetition, because at the beginning it says a person whose regular occupation, and then at the end it says on a professional basis. So you may have the impression that there's a sort of a repetition, because professional might be understood as something which is done on a regular basis, professionally. But actually, there are different views on these concepts. Unfortunately, MiFID does not provide us with additional clarification on how we should intend these terms. What is a regular occupation? What is effectively a third party? What is effectively professional? But there is a general agreement as to the fact that professional is not a repetition of regular occupation, but it is something that requires a certain level of organization, and organization made up of productive factors such as capital and labor, a combination of typical productive factors in an economic activity. As I said, the MiFID II does not provide further guidance on these fundamental topics, and therefore this is left to interpretation on the basis of national law, first of all, because MiFID is a directive, and this part of the directive is implemented in national law with different wordings. And therefore, you may find that the idea of what is a regular occupation in one European country is not necessarily the same of that which you find in another European country. And this is a big problem, because MiFID II is intended to be a major piece of European capital markets legislation that is based on the principle of mutual recognition, a European passport, but evidently on these fundamental topics, you might find different views from one member state to the other. Now, ESMA is doing a great job in trying to put together different views of member states in relation to many aspects of MiFID, including these. If you wish, you can also take a look, and you can understand how comprehensive this is. If you take a look at this document, there is a long Q&As on MiFID II by ESMA that you find on ESMA's website, and it's a typical Q&As section that is regularly updated, where ESMA provides answers to the questions that come up in relation to different aspects of MiFID. There are also questions that touch these fundamental sort of concepts of MiFID, but you know, ESMA is very important. They're doing a great job, but ultimately, when it comes to applying these rules are applied at national level and by national courts. If a controversy comes up, it's a national judge that would apply these rules, and you shouldn't take for granted that ESMA's position is upheld and adopted by a national court. What we would need on these big concepts of MiFID is naturally a decision by the European Court of Justice. You know that the ECJ is the only European institution that can provide a binding interpretation on European law, but we simply don't have cases where the Court of Justice has been addressed in order to clarify the scope of the directive. So this leaves us with, you know, a big normative package that still has some points of clarification to be further developed when it comes to these fundamental concepts. But for the moment, I think it's enough for you to sort of grasp the idea that an investment service falls within the directive when it is provided according to certain standards. It needs to be regular, it needs to be carried out on the market vis-à-vis third parties, and it needs to be carried out on a professional basis. And professional basically means sufficiently organized basis. Let me make an example. If an individual, myself, provides some kind of investment service on the market, such as investment advice. So I advise somebody to buy a certain security because I think it's a good investment. Okay, that would be investment advice under the definition of investment service. The question is, would I need to be licensed in order to do that? Bear in mind that the question is very important, because if you answer yes, then I need a license, okay? And if I do that, if I provide that advice without a license, in most member states, I would be committing a criminal offense. So I would be at risk of being convicted and sent to jail because I am carrying out an activity which should be licensed under MiFID, and I have no license at all. Now, first of all, you can say, well, you don't need a license because you're not a legal person. You are an individual. Yeah, okay, but beware, because differently from banking law, in MiFID, there is a provision on the basis of which member states may include in the definition entities which are not legal persons, such as corporations, but they are individuals, provided that certain conditions are met. Now, in fact, most member states have used this option in the context of investment advice. And also in Italy, we have individuals which have a MiFID license for investment advice on the basis of this exception of the directive. So that comment is a good comment because it catches the point that under Article 4, only legal persons are covered by MiFID, but then you have to consider that most member states have included in the scope of MiFID for some kind of services at least, and investment advice is one of these services, also individuals. This has been done because we feel that it's good for competition on the market that not just legal persons but also individuals may provide some kind of investment services to their clients. But once again, I'm providing that investment advice. Is it criminal offense if I provide it with no license, even if my national legislation includes natural persons within the scope of the directive? In order to answer these questions, I would need to verify whether I'm doing that on a regular basis, Okay, whether my clients are truly third parties, this is a gray area a little bit, because suppose that my, so to say, clients are members of my family. Members of my family. Would this be third parties? Technically speaking, it's open to interpretation, because there is no clear-cut exemption in MiFID under that, so a national court would have to say whether effectively these are third parties or not. And at that point, they may start distinguishing between close relatives, not too close relatives, distant relatives, and so on, and it becomes a mess and very subjective in the end. And then it needs to be organized in some way, professional. I may simply provide this investment advice like that, without having a structure such as employees or info provider services that would support me in providing these investment advices on a sufficiently organized basis. Okay, so you see that the answer to the question may change on how you answer these questions, but certainly what you can say without any doubt is that the simple fact of providing an activity on a one-shot basis, which may fall in the scope of investment services, is not enough, because you need regularity, you need third parties, and you need professionality, which basically means sufficiently organized. Okay, so the scope of MiFID is a good example of how the balancing exercise between costs and benefits of the regulation can be handled. You may be more or less dissatisfied with the upcoming result. We do feel that Article 4 leaves the space for too much interpretation at national level, especially by national courts. But by the way, it is interesting to see how you can effectively structure this balance by avoiding to apply on an overall basis a piece of legislation that might impact heavily on the costs of the system without providing sufficient advantages. Because one may wonder, what is the scope of applying MiFID legislation to an activity which is provided on a one-shot basis with no regularity, and where you do not really see that you have, clients on the market that have access to that activity. If you think about it, it would really imply placing too many costs on the systems vis-a-vis the potential advantages. Okay, we also saw on Monday that MiFID also applies to credit institutions, and remember that very interesting exception to the silos system of European financial law that we saw on Monday, and that relates to structured deposits, which are typically banking products, so they should fall under the scope of CRD4. They should have nothing to do in principle with MiFID because they are deposits. But since these deposits have some kind of flavor which makes them close to a financial product, because they have an interest rate which is linked to complex parameters, then they are considered as financial products, similar to financial products, and they are regulated under MiFID. Okay, I remember on Monday I told you that if you have a deposit that is linked solely to an interest rate, such as Euribor or LIBOR or whatever, this is not a structured deposit. You need some kind of complex index or more complex parameter, which is not simply an interest rate, in order to qualify a deposit as a structured deposit. And at that point, that deposit would remain a banking deposit under CRD4, but it would also be regulated by MiFID according to the new approach that we've had in MiFID. Okay, so keep in mind this topic of structured deposits, because it is important and also interesting at a macro level, just to understand how far we are going in sort of thinning down the silos between the three different silos of European financial legislation. So the MiFID II gives us a precise list of what we mean by investment services. It is different from CRD4 because in CRD4 the task was probably more straightforward. The definition of a credit institution is one business, credit institution, banking activity. And we know that this is made up of two elements, collecting deposits from the public and granting credit, and that's it. But in MiFID II, it's much more diversified and even less straightforward if you think about it. So we have a precise list of what we mean by investment services and activities. And this definition, or these definitions of investment services and activities, is based on another definition, which is the definition of financial instruments. When I say it is based upon another definition, this is because the investment services and activities are services that, as you see in the slide, these are services that relate to financial instruments. So you have to look at the two definitions in a combined way. It might be that you have an activity that is in the scope of investment services, but it is not relating to financial instruments. Typical example, again, could be investment advice. Okay? Investment advice, as you see from the list, and as I already anticipated, is one of the investment services included in the list. But if you're providing investment advice on, for instance, real estate, works of arts, precious metals, diamonds, maybe some of you is a passionate for vintage cars, automobiles. Well, all of this stuff is not included in the definition of financial instruments. So it would be investment advice, but since it does not have as a topic financial instruments, it would fall outside the scope of the directive. So you see that the definition of the service must always be combined with the definition of financial instruments. If a service is there, but it does not relate to financial instruments, it would not be MiFID relevant for MiFID purposes. Okay, so this is the list that you see. Take a look at it. Just read it through by yourself. A couple of seconds. No, not just a couple. Let's say 15 seconds. Okay, read it through. Okay, and now let me ask you a question. Do you feel comfortable with this list? By simply reading it on the basis of your knowledge, do you truly understand what we're talking about? Is it sufficiently clear? Give me your thoughts. It may be that you tell me yes. It doesn't necessarily mean you have to answer no. Does anybody here think that, I mean, we could simply now close the lesson and go and have a walk? Apart from the fact that I'm not sure whether we are able to walk outside, but because of the orange, dark orange zone we are in. But are you okay? Is it clear? I mean, do you have a clear understanding of what, for example, portfolio management means here? Yeah, right, Chiara. Portfolio management, yeah, wide landscape. Exactly. Orazio, thank you for your comment. It's very broad and also a bit disturbing because, I mean, look at number 9. What is an OTF? Okay, so it needs clarification. And it's quite differently from banking, because banking is basically everybody who has a minimum knowledge more or less has the idea of what a bank is. Then you can discuss what is a deposit collected from the public, but basically we know what we're talking about. This is much more technical and needs clarification. And naturally, as always, when you enter into these territories of European law and you have to clarify, you have political choices coming up, because the point of equilibrium of this legislation is very, very delicate and complex. It touches big interests of the industries. Because if you end up by applying these notions on a wide basis, you have a lot of business which comes into the scope of MiFID at a European level. And this has its pros and cons. If you instead adopt a narrower approach, you have a lot of business falling outside the scope of the directive. And this has a lot of pros and cons. The most evident points of discussion are, protection for investors. If you're very wide, you have a lot of more protection for investors on the European market, because this is what MiFID wants to do. It wants to protect investors. But on the other side, you increase the cost of the system. And the industry is never happy about that. So they would basically prefer, in this respect, a more restrictive approach. But also the industry has, different views, because if you narrow down these definitions, you have a lot of business that falls outside the scope of the directive, but also a lot of business which is not covered by the European passport, and which is one of the big advantages of MiFID, because MiFID gives to market players a license, which then they can use very easily all across the Union in 27 member states. And this is a huge advantage of this legislation. So it is not necessarily true that the industry would like to run away from MiFID because it's very cumbersome, it's expensive, because yes, it is, but it has its advantages. And ultimately, they would also say that most of the costs that are implied in applying MiFID would then be transferred to investors and to the markets in terms of costs of services. Okay, so it's a very interesting area where you can sort of reason in terms of what is appropriate, costs and benefits of regulation. But let's go back to our list. We have 9 items here. And we will now discuss each of them, trying to understand what falls inside. But let me point out 2 significant elements. The first is that number 4 and 5, I have underlined these 2 services. I have done that. There is no underlining in the text of the directive. And I have done this because these 2 services are the ones which are subject to the most stringent rules of MiFID. They are 2 services where the directive feels that investors should be particularly protected. We will see that we have, for example, one of the most important conduct of business rules in this respect is suitability, which is designed in order to protect investors from taking bad investment choices. And this rule and other rules only apply to portfolio management and investment services. And the reason for this is that, as we will see in the next slide, these 2 services are discretional. They imply an element of discretionality, because it is actually the investment firm that decides on behalf of the client, portfolio management, or actually advises the client as to what might be his investment choices. And this is why they need to be singled out in the list, because they are different from the other services that do not imply this element of discretionality. And then look at item 8 and item 9. Now, multilateral trading facilities and OTF, we will discuss these extensively throughout the entire MiFID part of the course. And what we're talking about here, as we saw on Monday, are trading venues, markets. It's actually the new version of the stock exchanges, the things we saw on Monday in the video, the outcry market. You remember, it's what came next. But the first question is, we're talking about markets, we're talking about stock exchanges. Now, in any book on finance, on the theory of finance, that financial markets, I mean, not theory of finance in general, but in any book on financial markets that you open up, at the beginning, you usually find, you know, an introductory chapter on what is the financial system, what are we talking about, and the author of any book on financial markets would say that the financial system is made up of different components, basically three: investors, intermediaries, and markets. Yeah, intermediaries and markets. What's happening here is that intermediation, which is basically items from 1 to 7, is mixed up with markets infrastructures. And this is very interesting. This is what happened with MiFID I, when the directive actually introduced for the first time a comprehensive regulation of trading venues. And this reflects this approach, which might seem strange because it disrupts the distinction between intermediaries and markets, is a product of market evolution. Because over time, financial intermediaries, such as broker-dealers, market makers, internalizers, have gradually been providing services on the market that are absolutely similar to those provided by a traditional stock exchange. A stock exchange provides two fundamental functions: price formation mechanism and liquidity. This is agreed by anybody. Now, these two functions traditionally were functions of stock exchanges, but thanks to technology, intermediaries can provide similar functions. Let me make an example. If an investment bank builds up a software that allows its clients to exchange securities through that system, okay, it's very easy because technology is very cheap in this respect. You build up a system that allows the clients of a bank to exchange securities through that system. What's going on? Is this financial intermediation, or is it building up a market? It's both. It's both, because the service that's being provided in terms of intermediation actually results in providing services which are similar to those provided by a traditional stock exchange. So over time, the borderline between markets and financial intermediaries has slimmed down. There is a huge amount of literature starting from the United States in the 1990s, late 1990s, where this transformation is described. You know, financial firms transforming themselves into something which is similar to a trading venue. And I think that this list, it is a list, so apparently it is boring. It doesn't provide any particular, it's not particularly sexy, but instead it is very interesting because it combines investment services intermediation with markets infrastructure. Because number 8 and 9 are trading venues, so they are markets. They are not traditional intermediation, financial intermediation. You may think that MiFID is about financial intermediation, but it is not. And now you also understand why it is called MiFID, markets in financial instruments directive, because the accent falls not just on investment services, but on markets and markets infrastructures. But even though what I have been saying is true, there is a but. And the but is that we do not see in this list the most important trading venue that still we have in Europe, which is the regulated market. Regulated markets are the old stock exchanges that have been renamed, and this already happened in the ISD, as regulated markets. So Euronext is a regulated market. Borsa Italiana is a regulated market. LSE was and still is a regulated market. And that's the most important trading venues we still have in Europe. We have these other new trading venues coming up. We will see what is the distinction between a regulated market and an MTF and an OTF. These have been regulated by MiFID I, and now MiFID II has added item number 9, OTF. But where are regulated markets? Why don't we see regulated markets in this list? The answer to this question, if you look at the directive, is pretty straightforward. Regulated markets are in the second part of the directive. On Monday, I told you that MiFID is divided into two pieces. The first part is on investment services. The second one is on trading venues. And you find regulated markets in the second part. But they're not included in the list of investment services and activities because they have a special status within the directive. And the special status is not something that comes up from MiFID, because from MiFID, regulated markets, multilateral trading facilities, and OTFs are exactly the same. This distinction comes up from the rest of European financial markets legislation, because in European financial markets legislation we have some provisions, very important provisions, that only apply to companies that are listed on regulated markets. The most important of these provisions is the Takeover Directive. The Takeover Bids Directive, and this only applies to companies that are listed on regulated markets. Another important provision is that in the prospectus regulation we have the specific rules for listing prospectuses when a company is listed on a regulated market, and these rules do not apply when a company gets its securities traded on another trading venue, different from regulated markets, such as multilateral trading facilities. So regulated markets have a special status under European law, but not because of MiFID, but because of other provisions of European law that are applicable only to regulated markets. And this explains why regulated markets are not included in the list of investment services and activities, but they are left only to the second part of the directive. As a consequence of this, as a consequence of this approach by MiFID, what we end up with is that investment services and activities, the list that you see, is open, is something that investment firms and credit institutions can carry out. So a multilateral trading facility or an OTF is something that a bank or an investment firm may set up and manage on the basis of MiFID. But regulated markets instead can only be set up and managed by a regulated market operator, which is not an investment firm, and whose rules are to be found in the second part of the directive. And this is because regulated markets have this particular status. They're subject to these specific rules, but MiFID had to sort of accept this approach, but not because of MiFID, because of other provisions of European legislation. For MiFID, a regulated market or a multilateral trading facility or an OTF are exactly the same thing. Okay? But regulated markets need to be licensed and supervised on the basis of specific rules because of other provisions of European legislation. This also means that an investment firm or a credit institution, okay, they can be authorized to provide all of these investment services and activities, but they cannot set up a regulated market because the regulated markets are reserved to regulated markets operators. Okay, so remember this, an investment firm or a credit institution cannot set up a regulated market. They can only set up a multilateral trading facility or an OTF. But, on the contrary, a regulated market operator, such as Euronext, may operate a multilateral trading facility and or an OTF. So the other way around, a regulated market operator may operate an MTF or an OTF. Question: can a regulated market operator provide investment services, items from 1 to 7? I just told you that it can set up, apart from a regulated market, an MTF or an OTF. But can it provide, for example, portfolio management, investment advice? The answer to the question is negative, no. A regulated market operator can only add to its core business, which is regulated markets, MTFs and OTFs, number 8 and 9, but it cannot add items from 1 to 7. Okay, so there is a sort of a cherry picking. We have to combine activities and services in the scope of the directive. On the one side, don't forget, please, looking at this scheme, at this list, don't forget that we have a very important activity included in MiFID, which you don't see here, and this is regulated markets. And also keep in mind this distinction between entities and activities. Investment firms and credit institutions can provide all of these services from 1 to 9, and regulated markets are not included. And regulated markets operator can only provide activities so as to set up a regulated market or an MTF or an OTF, but they cannot provide the other investment services. So now let's try and understand better what we mean by the different investment services that we saw on the list. Let's start with the two sort of more value-added services that we saw there, investment advice and portfolio management. Investment advice is defined by the directive as the provision of personal recommendations to a client, either upon its request or at the initiative of the investment firm in respect of one or more transactions relating to financial instruments. My feeling is that this definition is in part pretty straightforward, no? It's common sense. If you open up the Oxford Dictionary of the English language and you search for advice, you would find something that more or less goes in this direction. Everybody knows what an advice is. Okay, that's true, but if you read it carefully, you see that the definition is actually quite specific. And I have highlighted in bold letters what is specific in this definition. It's two elements. The first is that in order to be investment advice for MiFID purposes, with all the consequences, you must get a license, you are supervised, you have the European passport, blah, 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 blah. The first element is that the advice needs to be personalized. to a client. Okay? The second is that advice, in order to be MiFID advice, must concern one or more transactions relating to financial instruments. So I already told you, beware of financial instruments, because if you're providing investment advice on real estate, it's not MiFID business, okay? Because real estate is not a financial instrument for MiFID, but that's okay. But personal recommendation or more transactions is quite specific. So I will make now two examples to clarify black and white. What is MiFID, what is not MiFID? Suppose that I am a financial analyst and that I regularly send out to a mailing list my reports and my recommendations on different kinds of financial instruments. I would send out, for example, a report where I study Tesla, and I end up by saying, I think it's a good investment, so my recommendation is it's a buy recommendation. You know the typical language of financial analysts: buy, hold, sell, overweight, underweight. And I'm sending this report on a regular basis on different instruments to a list of 50 people. Is this MiFID advice? Do I need a license under MiFID to do that? No, because this is not a personal recommendation to a client. It's a recommendation that, I mean, it's not targeted to suit the needs of a specific client. I really know nothing about the investment objectives, the financial situation, the expectations in terms of investment profile and risk of these 50 addressees. And my recommendation might be okay for one client, but not okay for another. And I'm not providing any suggestion thereby. I'm just providing a recommendation on a certain instrument, but it is not personal to a client. So it's not MiFID advice. Okay? This is clear? Any questions on this? The other example, suppose instead that I know my clients very well, each of them. I know because they provided me with information on their financial situation, on their investment objectives, and so on. And I suggest to each of them or to one of them, I provide the following suggestion. Increase your exposure on Italian securities, because now we have Mario Draghi, who will save us all from disaster. And the Italian economy will recover and grow quickly after the pandemic is over. So increase your exposure now, when prices are low, on the Italian market. And I am targeting this recommendation, taking into account the profile of my mailing list. For example, I would not send this recommendation to someone who told me clearly that he doesn't want to have anything to do with Italian securities, or that he has an investment objective which is a very, very long-term investment objective that is not based on a sudden recovery of the market in the near future. Would this be MiFID advice? The answer to the question is negative, because it is personal, but it is not an advice on one or more transaction. By simply saying, increase your exposure on the Italian side of the market, I'm not really recommending a specific transaction. I'm recommending an investment strategy maybe, but not a transaction. And so this would not be MiFID advice. Okay, and so you see, it seems okay. You might feel comfortable because you know what an advice is. But then when you look at the definition, you discover that it's a combination of very specific elements. And if you lack these elements, this would not be MiFID regulated. The same applies in relation to portfolio management. Chiara, a few minutes ago, was commenting on the chat. It's very broad. Apparently it is, yes, but it's also quite specific because you see that MiFID captures portfolio management when it implies an element of discretionality. So the portfolio is managed on the basis of a mandate provided by clients. So you need a mandate, you need an agreement to manage those portfolios, and on a discretionary basis. So it will be the investment firm that decides what to buy, what to sell within the scope of the mandate provided. And also it is a client-by-client basis portfolio management, client-by-client basis. And this is important to remember in the future because once we're over with MiFID, we will look at fund manager, at fund management regulation in the EU. We have two directives there on funds, investment funds, UCITS and the AFMD. And fund management is portfolio management, but it's not client-by-client basis. A fund management activity is a collective portfolio management, which is carried out in the interest and on behalf of the fund and all the investors globally considered, while portfolio management in MiFID is client-by-client basis. And once again, this is important to also draw the borderline between MiFID and other capital markets directive. Now, these two services are considered as implying a fiduciary relationship between the client and the investment firm. In investment advice, because the service is personalized and is specific, the client builds up a lot of trust in the investment advisor. And this has its advantages, but also its risks, because MiFID wants to protect the client from the risk of abusing this fiduciary relationship that the client has with his investment advisor. And the same applies to portfolio management, but this is even riskier for the client than investment advice, because in portfolio management, the investment firm actually holds the assets of the clients that it manages on a discretional basis. And since it is discretional, the firm doesn't need to ask to the client whether he agrees or disagrees with its investment decisions because it's discretional. Okay, so these are two services where we will see that MiFID comes in with particularly strong rules of protection for the benefit of the client. We then have the other investment services in the list. Execution of orders and dealing on own account are the two traditional brokerage services that have always been on the market, including the one that we saw on the outcry market where Alain Delon was speaking on the phone with his client. He was taking the order and executing it on the market. That's typically brokerage. Okay. Now we have electronic trading, so the situation is completely different in terms of infrastructure and technology. But MiFID has sort of captured the traditional businesses that you found on the market before the reforms of the 1980s. And this would include execution of orders and dealing on own account. I assume you are familiar with this distinction, but if you are not, take a look at this slide 20, where you see the second part, the second and third paragraph of the slide, a brief graphic representation of how execution of orders vis-a-vis dealing on an account works. Now, in execution of orders, you have a typical brokerage structure. You have a client that places an order with an investment firm, and the investment firm executes the order on the market. In dealing on an account, instead, it's proprietary trading. So the order is executed with the investment firm as a counterparty, and it is not placed on the market. Okay, please beware that in the slide, reference is made to the market in very generical terms. So do not make the mistake, don't make the mistake ever of thinking that execution of orders ends up with an order executed on a trading venue such as a regulated market, an MTF, or an OTF. Because over-the-counter transactions that are executed outside the trading venues are perfectly within the scope of execution of orders. Okay, so market needs to be intended in a very wide sense. This is why in the slide you read market and not trading venue. Okay, so it's important for you to sort of take into account this element. Now, going back to this distinction between proprietary trading and execution of orders, you also have to remember that in MiFID, when you look at proprietary trading, you have specific rules that apply to two cases of proprietary trading. And these are subject to specific provisions in the context of MiFID. And the first of these particular proprietary trading is the systematic internalizer, and the second one is market making. And these are subject to extensive specific regulations in the context of MiFID. Okay? Now, a systematic internalizer is defined by MiFID as an investment firm that carries on proprietary trading on an organized, frequent, and systematic basis. Okay? Now, you may wonder, rightly, what is organized, what is frequent, and what is systematic. It's very technical because the directive and the technical standards, RTS, under the directive, are very analytical in providing clarification in this respect. It's a mixture of quantitative and qualitative aspects that have been clarified in technical standards, and you shouldn't really be concerned with that. But the idea is that when you have the proprietary trading that is carried on through a platform, through an organized structure that is accessible to clients that may use that structure on a regular basis, and when this is done in a relevant way in terms of volumes, number of securities, and so on, then what's actually happening, again, is an interesting phenomenon, because our dealer that uses proprietary trading is really becoming something similar to a trading venue. Because once again, he would be providing to the market on a stable basis a service which is pretty close to that of a trading venue. It's done on a regular basis, organized, it's open to access by clients, and therefore it is quite similar to a trading venue. But what is the difference between a regulated market, an MTF or an OTF, trading venues, and the systematic internalizer? The difference is that on a trading venue, you have a system which is multilateral, because you have orders coming on the venue from different investors, and these orders are combined together and executed through the system, and it's multilateral. In a systematic internalizer case, instead, it's bilateral, because the client that accesses the system executes the orders with the systematic internalizer, which is using proprietary trading. Okay, so that is the difference between trading venues and the systematic internalizer. Okay, is it clear? The difference between systematic internalizers and trading venues is that they perform very similar functions, but systematic internalizers are bilateral, while trading venues are multilateral. I must say, it's interesting to remember that in MiFID I, systematic internalizers were considered as trading venues. They were subject to the same rules. But in MiFID II, they have been taken out of the definition of trading venues, and they are now included in the particular rules applicable to dealing on own account, okay? Because of this bilateral structure rather than multilateral. A market maker is another particular way through which proprietary trading can be carried out, and this is linked to, you have market makers on different kinds of markets and securities. They are frequent in the field of derivatives, financial derivatives, or commodity derivatives, depending on the case, and also illiquid securities. And these are dealers who engage in providing liquidity to the market. They actually take up an obligation to provide quotes to the market on a regular basis in order to provide liquidity and also to sort of reduce price volatility on the market. This is especially true for financial derivatives. You have market makers that provide quotes in order to reduce price fluctuation and volatility on the market of these securities. And market makers have a very important function on trading platforms, and this is why they are subject to particular rules in terms of transparency, pre-trade transparency, transaction reporting, and so on. The other investment service that you find in the list, which is closely associated with dealing, it's actually the first service of the list of MiFID, is reception and transmission of orders. And let's look at the scheme again. You see, it's the first part of the slide. It's pretty straightforward. In a reception and transmission of orders case, you have two investment firms that are involved. The first one, IF1, is the firm that receives the order from the client. But differently from the second part of the slide, it does not execute the order directly, but it passes the order over to another investment firm that then executes the order on the market. Okay. In theory, you can have cases where the chain is longer, and instead of having just two investment firms, you can have three or four. Number one, passing the order to two, passing the order to three, but this is rare because if you lengthen the chain, you reduce the timing and the efficiency of the order execution phase. So generally, in most cases, you just have two passages, reception and transmission of orders by the first one, and then the second one executes the order on the market, generically speaking, market, not necessarily a trading venue. Okay. Now, reception and transmission of orders usually takes place when IF1 does not have access to the market of execution. For instance, this is very common when the client is a client of IF1, but not of IF2, and he is asking IF1 to place an order for securities, for example, on a foreign market, such as an Italian client that is a client of an Italian bank and wants to buy securities on NASDAQ or the New York Stock Exchange. In most of these cases, the IF1 is not a member of the market where the order should be executed, does not have direct access to the market. So what the Italian bank or investment firm would do is to take up the order and transmit it to a broker, maybe a US broker, or to a European broker that has access to the American market, which would then execute the order to the market. Okay. In the reception and transmission of order, the client never becomes a client of IF2 because the client of IF2 is IF1. Okay, and the client is only the client of IF1. So the contractual relationship and the protection that the client would get is a protection vis-a-vis IF1, and then IF1 would be the client of IF2. But the client is not a client of IF2 in reception and transmission of orders. The directive does not provide, these are all definitions taken from the directive, but let's go back to the list of investment services. For mysterious reasons, I have to say it's really a mystery why MiFID II is structured in this way. There is no definition of number 6 and 7. It's simply not there. You don't find a definition of 6 and 7. So you have to, once again, this again, therefore, is an area where potentially you have lack of harmonization because it's not straightforward what is underwriting, what is placing. Different member states may have different views. But that's it, and we cannot sort of fill in the gap by reading in MiFID what is not there. We have to look at the practice of supervisors across Europe and how these concepts are adopted and applied on the market. Now, underwriting and placing is basically the same activity. And what happens is that you have in these transactions generally a public offering on the market of securities. So you see that there is an issuer of securities. It can be maybe a company that is increasing its capital, issuing new shares on the market. It can be a company that issues bonds. It can be a big investor that offers on the market on the basis of a mass transaction a huge quantity of securities. This was typical, for instance, some years ago in the context of privatizations. In a privatization context, the state places on the market its stakes held in public companies, and this results in a public offering on the market of that amount of securities. So our investment firm would take up this task of placing on the market these securities, and this would result in activities number 6 and 7. You would most of the times have a public offering with a prospectus, but it may also be that in certain cases you have an offer which is only reserved to professional investors, which would then not require a prospectus at all. But most of the times you have a prospectus, and what the investment firm does is to place the securities on the market, and eventually, if you have number 6, as an investment service, the firm would also provide some kind of guarantee to the seller of the securities by saying if the market doesn't take up enough securities, is somebody underlining the slides? Because I am not. And do you see number 6 and 7 being at the moment underlined? And there is also a hand that is moving. I just don't understand whether I was wondering whether you have access to the slides as I show them, and so you can underline them on Blackboard. Just tell me whether this is happening. Otherwise, I have to report something is going wrong in the presentation. Okay, just tell me if you are underlining something on the slide. Nobody is. So it looks like a technical glitch, but I will notify this to the system because it's strange. I see that number 6 and 7 have been underlined blue. Do you see them underlined on Blackboard, or are they clear? Yeah, they are underlined. Yeah, I didn't underline them, so it's strange. Okay. Well, by the way, I was trying to understand how this might have happened. So I mean, let's go back to what I was saying. You have an entity which is placing securities on the market through a public offering or something similar, and the investment firm takes up the engagement to place those securities on the market, and it may provide some kind of guarantee to the seller. It might say, if the market doesn't take up those securities because there is not sufficient demand and you end up by selling only a part of those securities, I will buy them out of my own books. And this is providing a commitment basis to the seller. And it's a service that is usually provided in the context of public offerings by big investment banks, because you need big shoulders to provide this commitment to the seller. It absorbs a lot of capital, and it is usually only big investment banks that do take up this commitment basis, and they also get very high commissions. The issuer, or the seller of the securities pays high commissions for this commitment, but they are willing to do so when they feel that the market may be not so excited in taking up all the securities that are being placed. And they are ready to pay to the underwriter and to the distributor an additional commission for it to take up this engagement of ensuring that the public offering ends up well on the market. Okay, so, but there is no definition of 6 and 7 in the context of the directive, and you have to sort of identify it on the basis of market standards, and this implies some kind of problems. For example, there have always been divergences of opinions between the Italian supervisor, Consob, and the UK Financial Conduct Authority as to whether certain transactions would fall under number 1, as reception and transmission of orders, or under number 6 or 7. But I don't want to go too much into the details, but just to show you that it is surprising, because I told you MiFID is 2,000 pages of regulation, that we don't have, we only have a definition for certain investment services, but not for all of them. Apart from investment services, investment firms may also provide ancillary services. There is a list of these taken from the annex to the directive. This is what you find in the annex. You are not supposed to know this precisely. You're supposed to know what investment services are, absolutely, but ancillary services, I don't know them by heart, so I would never expect you to learn this thing by heart. But just to understand that investment services can, in addition to investment services, provide these ancillary services, and these are not subject to licensing in the member states. So unless you have other regulations that over time may take up some of these services, but at the moment it's not the case. And I think that it's only interesting to look at number 5 of the list, because there you see the distinction between MiFID advice and non-MiFID advice that we discussed a few minutes ago. So simply providing investment research and financial analysis is not MiFID investment advice. It's an ancillary service. Why? Because it lacks one of the two essential requisites, either personalization or the fact that the advice refers to a specific transaction. And this is confirmed by the fact that investment research and financial analysis end up by being ancillary services and not investment services under the directive. Okay, in this slide, we always have this client coming up. And I want to close today's class by telling you that we have different clients actually in the context of MiFID, because the directive wants to provide protection for investors on the one side. On the other side, we know, and this was a concept that was introduced in the ISD of 1993, that not all clients are the same. And in fact, the directive distinguishes clients into 3 categories. So after having said that a client is somebody who has a relationship with an investment firm for the provision of investment services, that's common sense. It tells us that there are 3 different kinds of clients in MiFID. And these 3 different categories have different levels of protections. The basic, widest protection is for retail clients. And retail clients are not really defined specifically, because the directive says a retail client is any client that is not a professional client. So it's a typical negative definition. You do not have a positive definition of a retail client. The directive says a retail client is anybody who is not a professional client. So you have instead a definition of professional client. It is very long. It is included in an annex to the directive, which is 4 pages long, written in Arial 6. I don't want you to be too much concerned with that. I think there is a group presentation or some papers on professional clients. So we will certainly step into this definition across the course. But basically, I want you to understand the basic approach. A professional client is a client that is in some way considered as an expert in financial matters. So he doesn't really need the same level of protection as a retail client would. And it may be an expert because of two different events. On the one side, he may be an expert because he is a professional market player. A bank, an investment fund, an insurance company is a professional client because that's what they do as a business. The other option is that it is a person whether a natural person or a legal person doesn't really make much difference, that has accumulated sufficient experience in financial matters. And this experience needs to be recorded and documented before the client is treated as a professional client. In this area, there is also another requisite that the client can be considered as professional if it is not a market player, if it has more than 500,000 euros of assets. And this is an element that sort of is singled out as being significant in order to understand whether a client who otherwise would be retail can be treated as professional. The third category is eligible counterparties, and these are a subset of professional clients that basically includes banks, investment funds, and they can be treated as eligible counterparties for certain transactions in the context of MiFID. So the highest level of protection is for retail clients, intermediate protection for professional clients, and very low protection for eligible clients. Okay, so this is the classification that you find in MiFID. And clients are naturally classified in one of the three categories, but clients can ask to be classified differently. For instance, a professional client, such as an investment fund, may ask to be treated as a retail client if it wants to have more protection under MiFID. And a retail client may instead ask to be treated as a professional client if he wants to have access to products or services which are conceived only for professional clients, but then he needs to meet the criteria in Annex 2. So there is a lot of flexibility in changing categories for clients. This has to be requested by the client. Please remember, bear with me for 5 seconds, there is no possibility, no retail clients can be treated as eligible counterparties. Okay, there is a limit to this flexibility, and the directive prohibits a retail clients from being treated upon request of the client or whatever as an eligible counterparty, because this would mean depriving the retail client of basically all the protection that MiFID conduct of business rules provide. So this is considered as very dangerous, and retail clients cannot be treated as eligible counterparties. Okay, but as for the rest, there is a lot of flexibility. Okay, so bear this in mind. No retail clients can be treated as eligible counterparties. Okay, so that's it for today. And on Monday, we will start looking at financial instruments and going deeper into the rules applicable under MiFID. Okay, any questions? Everything fine? Okay, so if we are set, I leave you to your next classes and have a good day. Bye-bye. Cheers.